bankruptcy implications for landlords. There have been some changes in bankruptcy over the last few years, which is why we want to understand it better as far as bankruptcies. We're going to start with a little primer on some key bankruptcy concepts. Then we're going to overview a couple of legislative changes that are federal legislative changes, among other things, because bankruptcy is typically federal. And then we're going to talk about what's happened with COVID and how that impacts us. And lastly, we'll talk a little bit about 2021. Margot is a great presenter. She has an amazing presentation set for us. There's going to be room for Q's and A's. I don't know if you want Q's and A's at the end or if you want them during the presentation. What would you like?
I'm good with either. I think that if we're hitting a hot area where people are really interested.
Well, I got a webinar going on right now.
Could certainly have questions during. So. But I will try to leave a little bit of time at the end too.
Okay, cool. So without much further ado, and with a big drum roll, you're on.
I'll go ahead and start sharing.
And I will mute myself. All of those of you that are not muted should mute yourselves so we don't get the dog barking and the etc.
Yeah, and I'm gonna apologize right now if you do if the dog gets in here. We're dog sitting right now, or my cats jump up. It's always a possibility. So I'll jump right in here and start with kind of a brief primer on some kind of key bankruptcy concepts for you, just to get you oriented. Most of the time when people talk about bankruptcy, you hear references to different chapters, Chapter 7, Chapter 13, Chapter 11. Those are literally references to chapters in the Bankruptcy Code book, which is a federal book. It's about 4 inches thick, which provides the code or the rules for different types of bankruptcies. But generally, despite the fact that there's kind of a variety of different chapters and different types of bankruptcy cases that can be filed, they really come in 2 main flavors. The first one is a Chapter 7 liquidation case. So Chapter 7 is the only chapter that has liquidations. This applies to both individuals and businesses. And generally, the idea here is that the debtor comes hat in hand to the bankruptcy court and gives full disclosure of all of their assets and all of their debts. And the court appoints a trustee, a Chapter 7 trustee, which is basically a liquidation agent that will marshal assets and sell them, and then take the proceeds and distribute those to the creditors of the debtor. So this could be for an individual, from your mortgage creditor, your car creditors to your credit cards, and for businesses, it could be from your the unpaid employees, taxes, runs the whole account. So the trustee will distribute any non-exempt sale proceeds to creditors. They do that in a priority fashion. So certain priority creditors get paid first. The trustee gets to take a fee first, and certain other creditors like tax creditors and employee creditors will get paid first. And then the general unsecured creditors will get a pro rata distribution, which means the larger your claim is, the more you get paid to the extent there are actually proceeds. Then at the end of the case, if we're talking about an individual, they'll get what's called a discharge of debts. You've probably heard that buzzwords in the past as well. Basically, all that is a court order putting in place an injunction that stops creditors from collecting debts once the case is over. That only applies to individuals who are going through a liquidation. It doesn't apply to a business in a liquidation. So for your purposes, most of the time you'd be dealing with, say, maybe a tenant in bankruptcy. If they're in a Chapter 7, they're not going to get debt relief, but at the end of the case, they won't have any assets to speak of. So there won't be, basically a practical way to collect more after that case is completed. generally speaking. And so the next reasonable thing to do in that case is to look towards guarantors to the extent there are any. The next big kind of bucket or type of bankruptcy is a reorganization bankruptcy. And that is chapters 11, 12, and 13. And primarily today we'll talk about chapter 11, which is for businesses and also high net worth individuals. Sometimes in the real estate area, we'll get individuals that are developers filing chapter 11s because they basically don't qualify for a chapter 13 because of certain debt limits. But the cornerstone of any reorganization type bankruptcy is basically a court-approved plan of reorganization. And to really boil it down, that's basically a piece of paper that lists off for the creditors how the debtor is going to pay them, who's going to be paid, when they're going to be paid, how much, and in what priority. For debtors in bankruptcy, really this bankruptcy code provides a lot of tools. It's essentially a toolkit that will allow debtors to modify certain creditors' rights. So for example, they can modify certain contracts. It's generally in the real estate world happens with like a lender that's secured by a piece of real property. If that loan is underwater, a debtor in a chapter 11 can cram down or reduce the amount of debt that's actually owed to that secured creditor based on the value of the real estate. They can also cut interest rates. There's say maybe a 10% interest rate right now. They can cram that down to the current kind of going rates around 4.25 for a cram down rate. They can also assume or reject executory contracts and leases. And we're going to talk about that a lot more in a lot more detail later in the presentation. But to give you an example, the large retail bankruptcies that we're seeing right now, oftentimes they'll identify locations that are unprofitable and others that are still profitable. And they'll use this as a tool to reject or basically terminate the unprofitable, the leases for the unprofitable locations and keep those or assume those that are profitable. And so it's just another tool in the toolkit, basically. We're also seeing Chapter 11 debtors increasingly, frankly, use Chapter 11 as essentially a mechanism to renegotiate contracts. Bankruptcy courts are very flexible as far as what they'll accept in a reorganization plan. And if a debtor can get, creditors and landlords and other interested parties on board, the court will generally approve that. And then lastly, I think it's important to kind of understand one final tool in this Chapter 11 toolkit. Oftentimes, large businesses will go into a Chapter 11 not really to reorganize, but to actually get approval of a stock or an asset sale to a third party. And the reason they do that is because if a purchaser of, say, business assets, is looking at the fact that the debtor is, say maybe there are multiple lawsuits that have been filed or there are general, debt issues, it's an insolvent company, the buyer doesn't want to inherit any of that. They don't want to have a successor liability issue where claimants will come out of the woodwork and try to assert claims against the new company or the new owners in a sale. And the great thing about Chapter 11 is that bankruptcy courts, and actually, frankly, judges will do this in a Chapter 7 too, so you can do a sale through Chapter 7, but bankruptcy judges will give these third-party purchasers, at least in a lot of areas in the country, a great bankruptcy order that says the third party is purchasing the assets or purchasing the stock free and clear of any liens or claims. And so they get like a really clean slate to start over again. And that is something that, that we're just seeing really used heavily, especially in the large retail filings and some of the restaurant related filings that are happening right now. So with that kind of, general context in mind, I want to give you just a few legislative updates of some current things that are happening and some new things in the last year. Just briefly touching on the Family Farmer Relief Act. So for, say, wineries, fruit producers, Christmas tree farmers in Oregon, the Congress substantially increased the debt limits to allow farms to file for bankruptcy relief. And we are seeing in Oregon and Washington, farms take advantage of that, and the filings are significantly up. So basically, any farms that have up to 10 million in debt can now file for relief. What's probably a little bit more interesting for you guys is the Small Business Reorganization Act. This was actually in the works before COVID, but COVID and the CARES Act has altered this somewhat. But basically, Congress just effectively at least earlier this year in February, put in place a new subchapter of Chapter 11 for small businesses. And the purpose here was to simply make it easier for small businesses to actually get through a Chapter 11 and survive. The success rate of small businesses in Chapter 11 is very low. And frankly, the success rate for any business, regardless of the size, is very low in bankruptcy. I read one statistic today, and of course, this does vary somewhat depending on where you are, if you're Oregon, Washington, or Delaware. But I saw a few statistics today that were trying to average things out and saying that basically less than 15% of debtors are actually successful in their Chapter 11 filings. So you can see that, there's just a high failure rate. It's a little bit hard to parse the numbers because sometimes debtors will go into a Chapter 11, propose a sale, and then convert to a Chapter 7. And that's not necessarily a failure. They may have done exactly what they set out to do, but they didn't actually reorganize in a Chapter 11. And so this new Small Business Reorganization Act was put into place to try to just simply make it easier. The scope of this, at least before COVID, was that it was specifically for small businesses with under roughly 2.7 million in debt. If you have disputed debts, those weren't included, but otherwise there were only a few other exclusions, including single asset real estate companies are excluded, and also certain companies with SEC reporting requirements. All that means is that basically public companies. This is not something for public companies. So I have a couple slides in here. I'm not going to go too far into the details, so we have more time to talk about really tools specific to.
Can I ask a quick question on that? Can you go back to that previous slide for a second?
Yeah, definitely.
So single asset real estate companies.
Yeah.
So Brian Pelkey owns a building and he has it in Brian Pelkey LLC.
Mm-hmm.
He's excluded from using the Small Business Reorganization Act?
Yeah, for that specific, if that is all he does.
That's Brian,
Yes.
all he does is he has this in there, and all he has is one loan in there, and his tenant failed.
Yep.
And now he has no income, and
Yes.
but he's not able to take advantage of this act. Is that correct?
That's correct. He could file a Chapter 11, a general Chapter 11, but he could not file a small business reorganization under this subchapter. That's correct. Which is a little bit unfortunate because it just really modifies the rules sufficiently that it makes it easier for people to survive and get through the other side.
Thank you.
Yeah. One way to possibly get around that would be to maybe diversify a little before going into bankruptcy. So there might be some strategies there. Anyway, just to give you just a couple tastes of why this is easier. Instead of requiring or looking at the plan terms for payment to creditors on a more long-term basis. This limits repayment plans for small businesses to 3 to 5 years. Basically, it's 3 years unless the court extends that for some good reason. And so it's a lot easier to get through a 3-year plan than say, you could easily even today have like a 7-year plan for a regular business in a Chapter 11. And instead of looking at the payment requirements to creditors generally as kind of a liquidation basis requirement. So for a normal company in Chapter 11, you have to, in order to get your plan confirmed, you have to be paying out creditors an equivalent amount, or basically more than they would receive in a Chapter 7. So for these large companies, you have to look at what do they own, what are their total assets, what are their debts, and especially with the national businesses that are in bankruptcy, if you look at some of their bankruptcy schedules, you can tell they're not actually insolvent. They have more assets than debts. And in those circumstances, normally you'd actually have to pay your creditors in full under a Chapter 11 plan if you're really not insolvent. So if you are insolvent, you'd at least have to pay out the amount that you could if you liquidated everything. That's a really high standard. They've modified that somewhat in for small business debtors, and they're really looking at net income after, so income after expenses, and saying, well, these small debtors just have to pay that to creditors over the life of the plan. Well, doing that for 3 years isn't that tough, frankly. And they've even built in some considerations where, say, if the debtor, needs to spend some extra money to improve operations, they can do that. So this is just is generally making it going to make it a lot easier. And we're really anticipating seeing an increase in these small business filings. We've seen some of them filed this year, but it hasn't, at least regionally, we haven't seen a huge tick up. I think nationally, the numbers are higher. Frankly, I think our region's actually just performing better economically than some of the rest of the country. And so I personally think we're going to see more fallout in 2021 and 2022. Bankruptcy is pretty much a lag indicator. So you see increases in filings after people really hit rock bottom. They're starting to come up the other side. So kind of moving on to COVID and how that has affected things, at least just from the legislative perspective. We got the CARES Act, which I'm sure you all know a bit about. But as far as the bankruptcy side of things, that actually substantially expanded the eligibility rules for the small business debtors. So now, instead of having roughly 2.7 million in debt and being eligible, you could have up to $7.5 million in debt and be eligible. This will sunset next year in 2021. So I think it's mid-year. I didn't put the date in here, but at least some pundits are expecting that we're going to get a rash of filings closer to that sunset deadline. It also provided some relief for Chapter 13 debtors, and of course the PPP loan program and the foreclosure forbearance provisions also really created a buffer, essentially, economically for a lot of groups of people. So what does that actually mean? Like, what are we seeing as far as bankruptcy trends in 2020? Well, we are seeing nationally a very substantial increase in business bankruptcy filings. I think that we're certainly seeing an increase in Oregon and Washington, a little bit in Idaho, but more than anything else, we're seeing a significant increase in more nationwide companies. And those filings you really see more in Delaware and Houston and sometimes California, but unfortunately, we don't get those in our local bankruptcy court. So often when we're dealing with those cases, we're we're dealing with, out-of-state attorneys that, especially in Delaware, actually charge about 3 times what I do. So it's a different economic calculus to try to represent, get representation and be actively involved in a Delaware bankruptcy than in a local one. Interestingly, on the individual side, we're actually seeing filings down. One statistic through June 1st was that individual filings were actually down over 15% for the year. I think that they are ticking up a bit, but they're still, I think this is reflective of the fact that, individuals are being able to take advantage of the increased unemployment benefits primarily. So we'll see what happens as that runs out here. As far as the business filings, we're really seeing more trends from, again, the nationwide kind of companies filing in particular to try to terminate long-term leases and to minimize damages paid to landlords, to address cash flow issues. Generally, we saw that, for example, with the Hertz bankruptcy, with rental cars. They just frankly didn't have the cash to keep operating, and so they needed some breathing room. Although they're a very solvent company, they just have a lot of hard assets. So we've seen filings for that purpose, and also a fair amount of companies that are liquidating, at least part, if not entire companies. For a little overview of some industries that are affected, we're seeing, again, large retailers. Frankly, I just picked a smattering of them when I kind of started to look things up for this. I mean, the list is very long. These were kind of the more compelling ones to me. There are also a ton of, East Coast large company names that I found. We're certainly seeing some of the fallout in the restaurant industry as well as hospitality. More locally, you may have heard that Blue Star Donuts filed for bankruptcy relief. The Gresham Hotel filed. We've had some more recent building contractor filings, which actually is odd to me because I've otherwise read that the construction industry is still fairly strong. And we're also seeing increases in farm filings. And then just generally a couple other things here. We haven't seen airlines filing, but there's been a pretty substantial tick up of airline related companies as well, like airplane part manufacturers, that sort of thing, as well as healthcare. And I do think that to the extent you have healthcare tenants, I have seen some of that flow through in Oregon with more national filings, but clinics and non-performing hospitals being shut down. So moving on to really nuts and bolts. So, you get a bankruptcy notice, what do you do? Kind of what are your steps and how do you kind of think through this process? The first step really when you hear about a bankruptcy is to confirm that there actually is a filing, for one thing. There oftentimes, for whatever reason with bankruptcy filings, there's such a lead up to the actual filing that sometimes businesses will indicate they filed before they actually have. You really don't have the cascading effect of a bankruptcy until you actually have that filing date. So that first piece of paper you're looking for is a bankruptcy notice. Usually specifically says notice or order for relief is sometimes indicated on there. It's different bankruptcy courts have slightly different names to this document, but it's a bankruptcy notice. And that document will have a number of deadlines on it, and that's something to keep track of. So there will be important deadlines. But after you confirm there's a filing, you need to stop all collection action. So there is another important injunction that is put in place whenever there's a bankruptcy filing, and it's called the automatic stay. And essentially what it does is it stops, it's intended to give a debtor, a business debtor or an individual breathing room. So it essentially stops all types of collection action and a variety of other types of actions that creditors would be taking against a debtor. So that's everything from, say, a lease enforcement litigation action that you would have filed maybe against a tenant, to, you know, commercial eviction action, to just a simple demand letter or a notice where you're trying to accelerate the lease or terminate the lease, that sort of thing. All of that has to stop. So the extent that something's right about to go out the door, you got to pull it from your outbox and make sure that it doesn't, because there are pretty significant ramifications for violating the automatic stay. You can be essentially sued have a little lawsuit within a bankruptcy case, and be responsible for not only paying damages, but also the attorney's fees for the debtor and even potentially sanctions. It's just not something to mess around with. So that's why I always say the first thing to do is just confirm there's a bankruptcy and then slow down and take a beat, and really evaluate how you're going to approach all communications with the debtor from that point forward.
So this means they don't have to pay their rent, or you just can't collect on damages?
Well, you can't collect on pre-petition rent. So you can't say send a demand letter for rent that was due as of the petition date. It's not that they won't eventually have to pay that rent necessarily, depending on how they treat the lease, but you can't continue to demand payment of the pre-petition lease amount.
But in order for them to stay in a suite or in the, you know, the whatever.
Mm-hmm. Yeah, I mean, in order for them to stay, they need to continue to make payments. However, you can't, if they fail to make payments during the bankruptcy, you can't simply send them your normal demand letter. You need to basically go to the bankruptcy court and get court approval to terminate the lease and kick them out, and, you know, try to collect what you can from them. And there's a specific process in the bankruptcy court for that collection, essentially, of the debt, which involves filing a claim and seeing if, you know, basically how the debtor plans to pay its claims.
Thank you.
That certainly isn't to say there aren't things you can do to try to force them to continue to pay, especially if they're going to stay there. It's just that those communications primarily need to be directed, you know, to their attorney, not directly, and also, you know, they need to not be aggressive demands to make sure that we're not violating the automatic stay. The next kind of steps here are really assessing the case and the lease treatment. So, you know, I look at big picture, say to look to see, well, you know, where did they file? Is it a Delaware filing, or is it something local? That will potentially impact how you approach the case. You know, do they already have a plan for how they're going to deal with the lease or deal with their debtors in general? In the case of the nationwide companies, you'll see that oftentimes they have a pre-packed plan, which just means they've already negotiated treatment with creditors. And so they actually, when they file, within, like, say, a week of filing, they'll actually have a plan of reorganization already on file. If it's a smaller tenant that has filed, or it's a local filing, generally you're not going to see that, and you could actually be waiting for up to easily, you know, 3 to 4 months before you even get a plan of reorganization filed. If it's truly a small business, under that small business rule, they have to file more quickly a plan. But it just kind of depends on where they're at and what type of plan what type of case they've filed. But you're really just looking to see, you know, what are their plans? Because if they are going to terminate the lease, if you've talked to them, you know that they're not going to stay there long term, then it behooves you to go to the bankruptcy court and get relief from the automatic stay to terminate the lease and get them out as quickly as possible. They do have up to 120 days to make a decision, though, about assumption or rejection. And so there is a lot of game playing that goes on with tenants where they will basically not necessarily tell you exactly what their plans are and wait out that 120 days. And after that, reject the lease. The good news, at least for post-petition, post-bankruptcy lease payments, is that those will be treated as priority administrative claims, which means they will get paid before general unsecured claims do. The bad news is that if the lease is terminated, the pre-petition bankruptcy claims will be general unsecured claims, and then the amount that you can claim as far as the rest of the lease damages is actually capped, which I'll go through in just a minute.
What?
Was there a question? Okay. And then the third step is to contact an attorney. I mean, frankly, if you handle a fair amount of these, I think that you'll get a rhythm to how these bankruptcy cases work, and you'll figure out what pieces of it you can handle yourself and what you need attorney assistance for. But generally, I think it is good to get some at least basic assistance from an attorney to evaluate the plan and the lease treatment, determine, how best to classify your claim on a proof of claim so that you get the best treatment. For example, classifying some of the rent that's due as an administrative claim is going to give you higher priority. An attorney can step you through all of that and tell you what your rights are in that context. And they can also file the proof of claim for you. So to step back for just a second, so I make sure I've actually explained what a proof of claim is. Basically, in a bankruptcy, instead of being able to, have this free-for-all where all of the creditors just come and jump on the debtor and try to get as much money as possible, the bankruptcy code and the bankruptcy court will dictate how and when creditors are actually paid, and to the extent they're actually paid. Sometimes you don't get paid at all in a bankruptcy. But the type of claim that you have, if it's a priority claim or a general unsecured claim or secured claim, will impact whether or not you get paid and how and when you get paid. And so in order to reserve the right to get paid at all, you have to file what's called a proof of claim, which is essentially a form that has just a number of requirements. It's fairly straightforward. Certainly if you end up doing this routinely, an attorney can essentially teach you. I mean, I have clients that I've taught how to do this themselves, so they can file and prepare proofs of claim themselves. But when you're first doing it, it's certainly good to get assistance in that process so that you maximize your recovery and actually get recovery. An attorney will also potentially help you through decisions about whether or not to vote for a plan of reorganization or to object to it, or object to certain treatment, lease treatment that's in a particular plan of reorganization. It'll also handle preferential payment disputes, and I'll talk a little bit about that in a bit. But there's a lot to navigate here, and it is good to have some assistance. So moving on to kind of nuts and bolts of how lease treatment works in a Chapter 11 case, there are just two options for a debtor. They can assume the lease. This is the best case scenario where they want to actually stay in the premises. They need to continue to perform and perform under that lease, and essentially they're retaining it. They can assign it to a third party, but generally the landlord can block that assignment because it has to be consensual. That has to do not only with the bankruptcy code, but most commercial leases as well have provisions about consent being required. And they also have to cure prior defaults. I'll have a couple notes on that in a bit though, because although that's how the bankruptcy code reads and how it is supposed to work, it doesn't work that way in all cases. And so there are some things to watch out for. The other option is lease rejection. This is literally essentially termination of the contract, and the tenant needs to get out, needs to get their stuff out. Sometimes, practically speaking, that doesn't happen. Sometimes the tenants will abandon personal property in the premises. In really messy situations that I've dealt with, sometimes there are secured creditors that are asserting liens on equipment, maybe purchase money liens on restaurant equipment or other equipment that's left in the premises. And, so there are sometimes priority issues between, say, a landlord's lien on items left in the premises and secured creditors liens. And then there's just, as you know, the joy of dealing with a bunch of useless crud that just needs to be tossed because, even if you sold it, it really wouldn't recoup value for anybody. And the damages associated with paying for that removal process. So those are really the two options. Practically, what does this mean? Well, if you have your lease rejected, your damages are statutorily capped, unfortunately. So the normal case, if I'm in state court and we're doing a lease enforcement case, we will assert damages for the entire remaining portion of the lease. So say you're in year 2 of a 7-year lease, we're going to claim rent for the remaining 7 years in addition to fees and other damages, getting the premises back up to in good shape and relet, etc. Of course, landlords do generally have a requirement to mitigate their damages, and you have to get back in there and try to relet the space to somebody new, and that will end up oftentimes offsetting the ultimate judgment amount that we get against a tenant in a lease enforcement action. Well, in a bankruptcy, since they're not going to they don't want to basically wait around for landlords to try to relet and then go through that lengthy process of figuring out, like, when did you get somebody new in there? What was the differential between the rent from the old tenant and the new tenant? And go through that process, which could take a long time. They just basically say, we're just going to cap you. We're just going to do a statutory cap. It's a pretty complicated calculation. It varies on where you're in the country because there are actually different judicial interpretations of this cap. So if you're in Delaware, it's different than if you're in Portland or Washington or California. But basically, the cap depends on, kind of the duration that's remaining on the lease and a couple of other things. But I think a real back of the envelope estimate is basically 1 year worth of lease of rent and CAM charges, plus any actual damages to the premises. So if a tenant trashed the premises or just otherwise there are repairs that need to be made. If you add those two numbers together, that is the absolute max that you can recover when you have a lease rejection claim. The landlord then generally just has a general unsecured claim. Again, we can talk about landlord's lien. Sometimes there's some value there, but oftentimes not. And unfortunately, in a lot of cases, at least, the small to mid business size business cases, unsecured creditors can, sorry about that. Unsecured creditors can really receive pennies on the dollar, if anything. So there are limits to what you can recover in this scenario. As far as lease acceptance, leases continue intact, which is great. You get to recover the past due amounts, except that is dependent somewhat on what's in the Chapter 11 plan. Debtors are supposed to follow the code, but they don't always. And they do tricky things where they'll say, yes, you're going to be paid your full amount of your damages, but what we're going to pay you is on this great schedule of, lease payments. And if between the time that they issue the schedule of lease payments and the time that you're supposed to file your claim, your damages are different, because you discover, say, that there is more extensive damage to the premises, you can get stuck with what they've put on their, kind of schedule of lease payments unless you object. So you just have to really, this is where I think it does come in handy to talk to the, try to have some open communication with your tenant about what their plans are, and really work with an attorney to review that plan carefully. Again, you've got to file that proof of claim. Then also another real red flag with large bankruptcy cases is that these guys will try to stick in third-party releases or injunctions into their plans. You don't see this in Oregon or California or Washington. Generally, our judges are against it. There's actually a lot of case law out there saying that these are impermissible. But in Delaware, it's a really, really common tactic. In Houston as well, it's a common tactic for these guys to stick in third-party releases, which means, in your context in particular, the release could be so broad that it could actually release a guarantor from liability under a lease. And that never really should happen, because a bankruptcy is only supposed to benefit the debtor in bankruptcy, not third parties that are not in bankruptcy. Often these guarantors have their own assets and are well-to-do, and that's exactly why the landlords have required them as guarantors. On the positive side, it's usually pretty easy to reject these third-party releases. So when the landlord as a creditor has the right to vote for or against a plan, there's often a provision on the ballot where there is a third-party release that basically is a checkbox, refuse the release. And so you can protect yourself there. There's really the option, but you have to know it exists, and you have to look for it, and you have to return your ballot. And what they're really counting on is a bunch of people just not paying attention and not returning a ballot. So, another practical implication here is that, we will see landlords try to kind of strong arm tenants into post-bankruptcy lease modifications. Basically, they'll use the lease acceptance rejection dichotomy as leverage, saying, well, if you don't agree to modify the lease to these very favorable terms, we're just going to reject your lease. There certainly is some, that is permissible under the bankruptcy code, unfortunately. But I think that it's also a little bit of a game of chicken. You really have to dig into it and figure out what the financials look like. Are they just trying to get a good deal, or are they not going to survive if they get the lease mod? One tactic I like is to try to build in basically more beneficial terms to the tenant for a shorter period of time earlier on in these lease modifications, and then build in some upside on the back end for the landlord. So if you do have to go down this road of a lease modification, when the economy improves, COVID's no longer around, that you get some upside on the back end. So I'm running a little short on time. So I want you guys to be able to ask questions if you have them, and have kind of a conversation here. I'm just going to mention this preferential payment problem, because it's another red flag to really understand. So if you have tenants that are kind of in a slide into bankruptcy, that they're struggling financially. Maybe they're talking about bankruptcy, or you're just generally concerned about bankruptcy, and they haven't paid for several months. If you get a lump sum payment from one of these tenants, and then they file bankruptcy, especially a Chapter 7, really this is primarily a Chapter 7 problem. It can come up in Chapter 11s, and they end up liquidating and filing a Chapter 7. The trustee, so that basically liquidation agent, can come knocking on your door and demand the payment back. So the general concept with bankruptcy is that it's supposed to treat all creditors fairly based on the type of claim that they have. And so two, say, general unsecured creditors would be treated identically in a bankruptcy. That's just a fundamental purpose of the bankruptcy code. The problem is, in the slide into bankruptcy, a lot of times debtors will, pay their uncle back for a loan that they, that they took out. Maybe they'll pay their landlord, or maybe they'll even prepay. Sometimes tenants even prepay rent in the future. But they'll kind of do these lump sum payments that don't reflect like a regular monthly payment. It's, kind of a lump sum that's making up possibly for past due amounts, or they're trying to prepay. The trustee will often come and try to unwind those. And so if you do have a debtor that's potentially going to file a bankruptcy, and you do want to enter into a settlement with them or accept a lump sum payment, it really is beneficial to talk to an attorney to strategize a little bit about how to structure that, because there are certainly ways to structure it to minimize your risk of exposure for a preference claim. For example, if you're giving consideration in exchange and contemporaneous consideration, like for example, maybe you're terminating the lease and you're going to give them a deal on what they're going to have to pay under the remaining term of the lease if they're terminating early, that can be sufficient to avoid a preference payment from being, a payment from being unwound and having to be turned over to a bankruptcy trustee. So especially if you're going to, accept, like do an early termination and accept a large payment, it's worthwhile to figure out how to structure that with an attorney to avoid some risk there. So that's the meat of it. We're at about 4:57. I thought I certainly have more content that I can talk to you about, but I wanted to see if folks have questions or want to discuss anything in particular here that might be something you're facing or interested in learning about.
In order to do it, you have to unmute yourself. Nobody's unmuting themselves. They're afraid.
Okay. Well, I can mention a couple of other things if people want, but okay.
Well, I think can we protect ourselves when a tenant files for? I think that should read, can we protect ourselves before a tenant files for bankruptcy?
Yeah, before.
Yeah, before. And I think that Jamie will say that we can see some tenants are running into trouble. They're running aground. Maybe it's a coffee shop chain that all of a sudden, well, one store is doing well, one store is not, and they want to file for bankruptcy to reorganize, and you're not sure if your lease is the one that's going to get reorganized out or somebody else's lease is going to get reorganized out. How do you protect yourself from that?
Yeah, so one thing that is useful to look at when you're starting to consider that is simply, are these leases, can you tell, are these leases all leases to the same tenant? Because one of the practical problems that I have seen on the tenant side in 2020 in particular with COVID is that folks have, say with I can think of a few examples, frankly, but a local ice cream shop chain that I have done work for has tried to protect themselves from liability by having a separate LLC for each chain, location, and essentially what is a small local chain. Well, that's not really a true chain structure. And if they were to file, they'd actually have to file bankruptcy for each of those LLCs, and they couldn't do the kind of acceptance rejection thing as easily. So kind of just the first practical question is, can you do a little bit of research, even with the Secretary of State website, and figure out, do these people have multiple LLCs? Are those covering each of the locations? What kind of bargaining power, can they legitimately argue that they are going to reject our lease? Or have they structured their business in a way that they actually can't do that? I'm finding that tenants have backed themselves into that problem because of other legitimate legal concerns when they're organizing, their entity formation. That asking some of those threshold questions is useful. I do think that in that slide into bankruptcy, you can certainly also start having more of a dialogue about requiring regular financial information, especially if you're kind of allowing some late payments. If there's some concessions that the landlord's giving, then if it's not in the loan documentation, you can still have that conversation even about, figuring out where do they really stand and what does this look like as you're going forward. So, one option is to actually do some lease modifications to try to put yourself in a little bit of a better position if you do end up looking at a bankruptcy as well. And primarily, although there's no silver bullet here, but to the extent if you say have a lease that doesn't have a guarantor on it, and you can negotiate a pre-bankruptcy modification and get a guarantor on the hook, certainly that can be helpful. Generally guarantors, will still be liable because it's, unless the individual also files for bankruptcy relief, which happens, it does happen, but happens less frequently.
Okay. Jamie, do you have any other questions?
Well, I guess mostly what we see in pre-bankruptcy negotiations are national tenants coming to us and saying, well, we've got this list of stores and we're going to close 25% of them. So if you give us a rent break, maybe you won't be part of the stores we close when we file bankruptcy. And we've had different clients respond differently with different results to that. And it's interesting.
Yeah, I mean, I think a lot of times it does actually just come down to how well the locations are actually doing. I mean, what I see, because I've had a number of scenarios where I actually have, represent even multiple landlords in the same, that each have tenants from the same chain. It doesn't necessarily matter. They often just approach everyone with that kind of shotgun approach. So to the extent you can actually, I mean, I think that's where it comes kind of down to, if you really know how that tenant is doing in that location, which can be very hard. I know that, you don't always know, but if you can get more information about how that location is actually doing, that can really help determine how you play that game of chicken.
We have a couple more questions.
Yeah, I was gonna say.
Question number one is, does an automatically generated tenant monthly statement, so it's, obviously property management companies typically do automatically generated statements, constitute a banned collection action under a bankruptcy stay?
Generally not, but I do say that you should look at those, because if they are, it depends on what the auto-generated statements say. So it's much less likely. The corollary would be like for my credit union and financial institution clients, they send, monthly statements on mortgages all the time. Generally, if they just kept sending their normal monthly mortgage statement, usually it's not a stay violation. But sometimes those statements, depending on how good or complex your auto-generated statements are, they may have actually pretty, big, bold demands for past due payments, and you want to avoid that. So definitely take a look.
All right. Second question from Matt Concert. If you have the principal's personal guarantees, those would not be included in their LLC Chapter 11 or SBRA, and could you pursue them thereafter, or would they be included in the Chapter 11?
So so the individual guarantors are not included in the Chapter 11, with one caveat. in the like national based companies, sometimes they will try to sneak a release into a third party release into their Chapter 11 plans. And those can be drafted so broadly as to be interpreted to release a guarantor. So that's the only scenario where usually a guarantor would be implicated at all in a Chapter 11. So there's no, like co-debtor stay in a Chapter 11 for commercial debt. So as long as we're talking about commercial debt and a commercial guarantor, you can still pursue them. And that really is, sometimes that becomes the collection strategy. It's just filing an action against the guarantor. It is possible for the guarantor to go into the bankruptcy and actually ask the court to impose a stay, a co-debtor stay. It happens pretty rarely though, and you would get notice of it.
Okay. Any other questions? Anything else? Going once?
What if I have one?
Yes.
Hey, we're involved with the donut company that you mentioned earlier, and their intent is to continue with the lease they have with us at the location they have.
Mm-hmm.
But we were listed in the bankruptcy documents as an affirmed payment for July and August.
Mm-hmm.
Does that mean that payment's protected from being recalled?
If they're paying you, since they've already filed for bankruptcy and they're paying you, probably what happened there. Well, there's two different ways that it may have happened, and I haven't actually looked at the filings for that company, but they probably needed a cash collateral order to approve certain payments. And so that's probably what you're listed on if it's only a couple months that they're showing you as approved. So that's probably a cash collateral issue. You would need to look at the plan to see if they have filed one, to see if they're assuming the lease or rejecting the lease.
Well, I'll continue to read. I just got it today, and that stood out to me, and I wasn't certain what it meant.
But I can tell you this: if you're receiving payments after the bankruptcy from the debtor on the lease, those are not preferential payments that are going to be recalled to you, or that are going to be clawed back.
That's good to know.
So you're safe on that.
So. Good.
Very cool.
Well, that answers my question. Thank you.
Yeah. Anybody else? Well, geez, Margaret, that was really, really helpful. I mean, for me, I've been through this more than once now, and so it's really, really good. Really sort of reinforced some things for me. I really, really appreciate it. Everybody, I'm going to give her a hand. Thank you so much.
Oh, no.
It was enlightening. And the next presentation is Abby.
November 17th. Here,
November 17th. Do you want to throw the slide up? Who's throwing the slide up?
Let me.
Oh, sorry. I can unshare.
Perfect. Thank you.
There you go.
All right. There we go.
November 17th, we're going to have Jennifer Young, Tax Director at Moss Adams. We'll discuss a myriad of tax changes that are on the November 20 ballot. As you know, there are at least 5 in Multnomah County tax issues, at least 5, with several tax measures on the November ballot. We'll have an informative discussion on the specifics. We're doing this after the election so you can figure out what really happened, because Multnomah County is about to get blasted with all sorts of requests for money. We'll be sending out invites to this event in the coming days, so keep your eyes on the inbox. Remember, just as an aside for a second, as you're thinking about voting, that as you vote on these issues, that on the residential side, which any of you are not involved with, there's rent control. So here you've got taxes that are going up, but you can't recapture it because you've got rent control. Not only that, on the commercial leases, we're seeing a lot of tenants have decided. Even today, we had a conversation about tenants that are giving up their office space for moving home. So there's going to be rent compression, and I think that there's going to be maybe not as much bankruptcy filing, but reorganization filings. We're in for still a run for our money. Thank you, everybody for coming. It was great to see you. Thank you, Margot, for a great, really thorough presentation, super slides. And we'll leave this open if you guys want to chat a little bit. You can talk on the chat box. We won't on the box. We won't shut this down right away. And if anybody have any questions here, you can do into the anybody questions. Thank you very much. See you all later. Thank you for coming.
Thank
Bye.
you.
Thank you.